Welcome, everyone, to the latest and greatest edition of Blueprints and Banter. I am your host, Steve Kona, President and CEO of Associated Builders and Contractors Florida Gulf Coast Chapter, and I am joined by the Chairman of the Board, Mr. David Tertios. Dave, welcome.
Welcome, Steve. Thank you for having me here.
You bet.
Again.
I bet. We have a great show for you today, but we want to start off by thanking our sponsors. So we'll let Dave do that.
Yeah, definitely. So for the 2024 year, our Diamond Advantage Club sponsors are Callista Cabinets, Skin Yard Company, Milwaukee Tool, and Piper Fire Protection. Thank you very much to those companies for supporting ABC and all of our efforts.
So, Dave, you know, there's so much construction work happening in our region. You see cranes everywhere. That means there's a lot of construction going on. And when there's a lot of construction going on, there's also a lot of construction contracts floating around out there. And today we wanted to kind of bring some education to our members about construction contracts, what they should be looking for, some pro tips. So we decided to bring in an expert in the field, our good friend, Justin Zinzow, longtime ABC member and board certified construction attorney. Justin, welcome to the show. Glad to have you.
Good morning, gentlemen. Thank you for having me.
You bet. Justin, tell the folks a little bit about yourself, and then we'll get into some questions about construction contracts.
Certainly. So I'm the CEO of a conglomerate of companies we call Team Z, Zinzow Law being one, which is a team of construction law experts that serve companies in the construction and development industry. Zindocs, which helps them get paid through pre-lien, pre-bond claim notices, and our foundation through which we give back to the veterans that support this great nation.
That's excellent. And Justin, you've been a longtime member of ABC and been involved in the process. I mean, not only are you involved in the legal process, but you're also involved in our political processes as well, and you're very active in that forum. So when it comes to construction contracts, the construction industry, you've been a great champion. So I just want to first off thank you for that, because I know it's a lot of work not only to do legal work, but also to be involved in the political process. So I just want to thank you for that just to start off.
Thank you. Well, I'm quite passionate about it and love serving our industry alongside you fine gentlemen. So.
Yeah, definitely. So yeah, definitely, Justin, thank you very much for being here. As Steve mentioned, obviously there is a lot of construction going on, which is great for us. But unfortunately with that comes a lot of different type of litigation issues as well. So the first question we have for you, Justin, is what pro tips do you have for reviewing or negotiating a construction contract?
Sure. Well, tip number one is read the contract. And I say that facetiously, but seriously. These things are getting longer and longer. And you really have to block focus time first and foremost. You know, we're all distracted by technology, emails, text messages, social media, but it requires a lot of memory and focus time to get through these things correctly. Next is, while I'm a huge fan of the digital era, there's nothing like printing and reviewing a contract in hard copy form. And the reason for that is studies have shown statistically that even an act of scrolling through a page reduces our short-term memory retention, the thing we need to be able to cross-reference all these complicated provisions. Scope of work, price, those are the things that folks jump to, the exhibits, the technical stuff. Obviously that has to be right, but you really have to review every word of it. There's no such thing anymore as so-called legal boilerplate. These things are definitely highly customized and highly detailed. Use a checklist. Many trade organizations have issue spotting checklists, or they put on talks like this, or contact your attorney and say, hey, I don't want to pay you every time for everything. Write up a checklist for me to issue spot some of my own things. And review all the contract documents. Most construction contracts incorporate other documents. And I can't tell you how many times, say in a business dispute, right, after the project has gone bad, or there's a dispute over time or money or delays, and we ask the client for the contract and we get it, and it says it incorporates the prime contract or a different subcontract or standard specification or something else. Say, hey client, can you please send that to us? And they said, well, we never got it. We never asked for it. Those things govern your rights and responsibilities. So you've got to get those, and you have the right to them. You have the right to request them. That's super, super important. Another thing I would say is trust but verify, to use a truncated version of the old Ronald Reagan adage. And that is, even if your construction contract you're being presented with is, say, an AIA or consensus docs or something that's a so-called industry standard form, review it carefully to make sure it's not actually been modified. Those companies require you to modify their documents in their software, which tracks changes. But many companies and their lawyers will try to sort of skirt the licensing fees those companies charge and retype these documents in their own systems. And then it doesn't track those changes. So don't assume if you don't see red lines or vertical lines on the sides of the page that the so-called industry standard forms, haven't been modified, because they may have been. I'm kind of my last tip on, things to look out for when you're negotiating a contract. Really, two tips. One, know your bargaining power, right? That changes depending on the construction economy. Now, trade contractors are in high demand and tend to have more bargaining power than the general contractors, prime contractors. That won't always be the case, but know where you are in that market. And then lastly, provide a copy of your contract to your insurance agent or your bonding agent, not just the portions on bond, not just the portions on insurance, because these provisions are very complicated. And there may be provisions, some of which we may talk about today, that implicate bonding and insurance. And you want to make sure that those folks have eyes on them, and they can be buried in sections that don't have a heading bonding or insurance.
I'm happy to hear you talk about, printing out the contract, because we're supposed to be in a paperless society, right? And so I sometimes get scolded for wasting the paper to print these documents out and reading them. But from a comprehension standpoint, I do better looking at the paper than I do at the screen sometimes. One thing that I want to just kind of reiterate what you said about making sure you read the contract. It sounds pretty, like it should be a common thing to do. Unfortunately, you're right. I think a lot of situations, everybody doesn't read the contracts. What we also advise our customers to do is, don't get complacent with if you get a second or a third subcontract from a general contractor. Just because it read one way the first time doesn't mean it's going to read the same way the second and third times. Sometimes changes are made, and these general contractors, they're not always trying to, act in a manner where they're trying to get a subcontractor. I mean, they have, as you said, attorneys on their payroll, and their job is to mitigate the general contractor's liability. So they'll sometimes make some amendments, and if you don't read the contracts and notice that, you could get yourself into trouble.
Absolutely, and I would add one additional piece, which is, okay, so you've read the contract documents, all of them. You've negotiated them, you've signed them. Now what? Right? Most construction companies, well, really all good construction companies, they know Gantt charts, critical path methods, schedules. You focus on that, right? Because the project has to be timely built. But there's all kinds of gotcha provisions in these construction contracts that impose, we'll call them legal deadlines, right? By the time you get to a lawyer, if you have a problem, if you haven't complied with those during the course of the project, you're in deep trouble. So you've got to create some kind of an abstract or something, distill these hundreds of pages down into their essences, what those trigger dates are, be ready for them just in case. Some of them are 24-hour notice provisions. And by the time you think about that, it's too late.
Yeah, and one other thing, Justin, with technology and everything that's happening in our industry, and people are trying to save money, we've heard of, people putting their contracts into Chat GPT, which, it's a great tool. AI is a great tool for our industry, but there's nothing like being able to get sound legal advice from someone who's seen multiple contracts and knowing exactly what your liabilities are before you sign said contract.
Well, courts are starting to impose sanctions on lawyers who are using Chat GPT. So that ought to tell you, at least on the legal front, the reliability or lack thereof of that tool, right now. Yeah,
no, for sure. So next up, so what are some of the most kind of problematic contract provisions that you've seen used, in later disputes?
Well, I'll start with the one that's the tail that wags the dog, attorney's fees. If you've ever been in a dispute and you wonder why it can be so difficult to resolve, it's oftentimes the attorney's fee issue, whether you're going to be responsible for the other side's attorney's fees or theirs for you. A lot of folks believe that you should include in all of your construction contract documents, regardless of whether you're the prime contractor, the subcontractor, project owner, whatever, a right to recover attorney's fees in the event of a dispute. But I would caution against that. Sometimes that incentivizes disputes, especially smaller ones. And when I say smaller, it could be 6 figures or low 7 figures. But if the adversary knows they have a chance at getting their attorney's fees recovered, they're more likely to fight. So be tactical about it. Think about the kinds of problems. If everything went badly, what could the fight look like? Is it just going to be you pursuing a payment claim? Well, if you've got a lien right or a bond claim right, you have a right to attorney's fees, even if it's not in the contract. That's statutory, right? On the other hand, if it's a defect or a delay concern, so just be mindful, and because that is wielded both as a sword and a shield and can make disputes extraordinarily difficult to resolve because it focuses more on the lawyer issue later than on the parties, the business decision. The next I would say is indemnity. Indemnity provisions are in pretty much all construction contracts these days, or at least sophisticated construction contracts, but not all indemnity provisions are made alike. Some are sort of vanilla that says, hey, if I do something wrong on a project, I will cover you for the damages and expenses you incur as a result of what I did wrong. But what if I was only partially at fault? Do I only bear a responsibility for a portion? Well, so the indemnity can say, no matter who's at fault, I will reimburse or cover those costs. In other words, I'm reimbursing you or indemnifying you, even if you are partially the cause, Steve or Dave, of that negligence or that damage. That way, there can't be a dispute to prolong that indemnity. These things can be heavily negotiated. So if you find one in your project contract, don't assume that you have to take it or leave it. This is another key area where providing the entire contract to your insurance agent is important, because you may actually be able to buy a policy or an endorsement to your policy that provides coverage for that indemnity. It's called the insured contracts provision. Some of them exclude coverage for those types of indemnities, some include, but a practical way these are handled is a dispute occurs and they say, okay, you hire an attorney, you go defend. Or there's all sorts of persnickety damages that you wouldn't normally be responsible for as a matter of contract law, but now you are. These things can be really brutal. The next I would say is termination for convenience or termination provisions. In the absence of any special termination provisions, parties can only fire each other for cause. In other words, there's been a material breach or a material violation of the contract. Can't be trivial, has to be material, significant. But in many contracts, there's something called suspension for convenience or even termination for convenience. If you're a subcontractor, for example, or even a prime contractor, and the owner has a termination for convenience provision in that prime contract, you better make sure you have them in your downstream contracts. Because when the owner, as an example, says, hey, this just isn't working out, but I'm not going to declare you in default, I'm just going to terminate this contract for convenience. Well, you've got to look downstream to everybody that you hired, and you have to be able to terminate them for convenience. Otherwise, your terminating them is a breach of your contract, and you can be on the hook for their lost profits. And again, not all termination for convenience provisions are the same either. Some of the trickier ones say, hey, if I terminate you for default, because I don't want to pay you anything more. And it turns out that a judge, jury, or arbitrator determines actually you were not in material default. I got it wrong. Then that default termination will be transformed into a convenience termination. Isn't that convenient? That means you can't come after me for wrongly terminating you. Well, these things are strictly a creature of contract. They can be wielded against you or they can be wielded for your benefit. So know what's in the contract documents and whether you need to make sure it's in downstream contracts. We see this happen a lot where it's just overlooked. Deadlines, as I said, watch those deadlines. I mean, if you're seeing phrases in your contract like before, or condition preceding, or condition subsequent, permission, consent, notice, like have your radar up, right? These provisions can be 24-hour turnaround or shorter. They can require notice to go not to your counterpart at your client's office. They could be, to headquarters in New York City, care of some person you've never heard of, and it has to be sent via carrier pigeon, not via FedEx or mail, right? We've enforced these provisions. They're brutal. We took a case all the way through to trial on behalf of our general contractor client enforcing a 24-hour notice provision. The sub did the work but didn't provide the notice. It got 0 after 3 years of litigation. 0.
Wow.
So they can be really tough. I would also say arbitration and litigation, right, is know that those are different. They're different in this sense. Arbitration is strictly also a creature of contract. The default is litigation. And if you are bound to an arbitration provision, you better make sure that flows downstream to your subs, material suppliers, et cetera, so that if there is a dispute, you can bring them into it to resolve the problem. Otherwise, you're fighting in 2 locations.
Sounds good. I like what you said about these all of the things to take a look at. Do you have any talking a little bit about the indemnity clause? Do you have any input to say about like liquidated damage or consequential damages? I know that's something that seems to be hairy in the surety world. We try to talk to our customers about being aware of that. Do you have any input about that?
Sure. So again, not all are made alike, usually heavily negotiable. Liquidated damages typically for delay, right? So it fixes the daily, weekly amount. They will be enforced as written unless they constitute a penalty. They're a penalty if they're so wildly disproportionate to what the actual damages might have been. This is common for hotel constructions, road construction, a lot of municipal construction. Unless the liquidated amount, it's a judgment call, it's a business decision. What if you fail to perform on a job and you delay it? What are the likely damages? If the damages are $100,000 a month and you can negotiate a liquidated damages provision for $50,000, then negotiate it into liquidated damages. Of course, the trigger, are you the sole cause of the liquidated damages or only part, right? Again, these are not one size fits all, provisions. So look at them carefully. As far as consequential damages, these are damages that are not reasonably foreseeable, right? So this is, you've liened the job, the owner claims your lien is improper, and as a result of your lien, the owner hasn't been able to sell or hasn't been able to refinance the project and is stuck in a high interest mortgage, right? The difference between the high interest rate and the low interest rate is a consequential damage because nobody would have thought that you would assert that at the time you signed the project. You can negotiate mutual waivers of consequential damages, which is usually what we recommend, right? That way it's easier for people to know going into a contract, here's the kinds of stuff I need to be thinking about and responsible for. I don't have to imagine or be blindsided by something I was never expecting, 3 years after the fact.
All right. No, appreciate that input. So last question we have for you. And I'm going to ask this one. So you're working on a bonded project and you're having trouble getting payment. What are the options?
Well, so first and foremost, if you're not in contract with the bonded contractor, right, the bond principal, you've got to serve a preliminary notice. You've got to serve that notice of contractor within 45 days of first furnishing of labor, services, or materials. Even with sophisticated construction parties, that is often overlooked. They get too comfortable in a relationship. They get too comfortable with the project size, or they wait until the first payment issue arises and they've already blown it. So our recommendation is when you sign the contract or you get the work order, serve the preliminary notice right then, because you can serve at any time before first furnishing, but no later than within 45 days. Next, of course, is make sure you meet the actual bond claim deadline if there is a payment bond at issue, and that's to serve a notice of non-payment within 90 days of final furnishing. Major warning, final furnishing does not necessarily mean your last date of work to the project. It is a term of art. It has to be your last work that was required by the contract, i.e. you weren't volunteering it just to provide goodwill. It has to be substantial. It can't be punch list. So there's a litany of factors. Make sure you timely serve your notice of non-payment. And know, importantly, at the time you're entering into a contract, you hear, oh, this is going to be a bonded job. Let's say it's a private bonded project. Not all bonds are made alike. Part of the contract documents include the bonds, or they ought to read them. They are what the sureties write them to be on private projects. You can have conditional payment bonds, which means the surety has no liability to pay unless the bond principal has been paid, or unconditional. Know the penal sum of the bond, which starts as the total project amount. But does the surety waive consent to change orders, or does it require consent to change orders, right? If the contract price increases and the surety hasn't waived consent to change orders, then you may find yourself with a bond that's insufficient in amount to cover all of the payment claims. So that's, those are just some of the tips that I would offer on bonded projects. Of course, every type of project is different. You have state and municipal, which is what we call a Little Miller Act bond. Those are in a certain statutory form, and those are handled a certain way. Same deadline applies, both to the 45 and the 90 day. And then there's federal project bonds, Miller Act bonds, which are a creature of their own and only secure the rights of a certain smaller subset of contractors, namely subcontractor on the project. So that would be kind of the quick overview, I would say, is, what kind of a bond is it, and make sure you meet your deadlines.
And Justin, just to kind of wrap everything up today, first of all, we appreciate you being here. But lastly, in the ABC network, we have a lot of small to mid-size subcontractors. A lot of them, because of the amount of construction work that we have right now, are actually, taking on some bigger projects, which means they're probably working for, some bigger contractors. Give me like a couple of words of advice for any of those small to mid-sized contractors that are taking on more work. What can they do? What advice do you have to make their step up to a bigger project more successful? Sure.
Well, first and foremost, know your weaknesses and hire your weaknesses, right? So that'd be, guys like Dave Tercios, right? Great CPAs, great law firms. Know where you need advice, shore up the gaps, right? And folks, these professional service providers, we don't just offer the technical. We don't just sell bonds or sell insurance or sell law. We're going to provide you practical business insights, because we see guys and gals like you doing this every day. We see the smart things they've done and the bad things they've done. So that's a big one, I would say. And that again goes back to the contract side, is do your due diligence there. Do your due diligence on your client. Yes, ask around. Yeah, look at Google, things like that. But you can also do like litigation searches. Just because somebody's been in litigation doesn't make them bad, but get some context, find out, who you're dealing with. And I think that will go a long, long way.
Yeah, no, for sure. And just being part of the ABC network, you have access to all the context that you might need in order to be successful in that. So, Justin, how can folks get a hold of you if they might need your help for a contract or some legal issues?
Sure. So law firm website is www.zinzowlaw.com. That's and then phone number 727-787-3121. And our affiliate, the notice company, is www.zindocs.com, DOCS.
Awesome. Well, Justin, thank you so much for joining us today on Blueprints and Banner. We appreciate your expertise, and we look forward to having you on again sometime.
My pleasure. Thank you very much.
You bet.
Have a good day, Justin.
You too.
We appreciate having Justin on. A lot of great legal advice, Dave.
Yeah, definitely great advice. Unfortunately, we live in a litigious society, so having access to quality attorneys who are specializing in the construction industry are very important.
Yeah. So let's tell people how they can help us.
Yeah, well, what we would really appreciate is getting more traction on this podcast. So if you are listening to this, I encourage you to share this podcast, let your friends and neighbors know about it. Go to YouTube, we can see us, and you can go to wherever you get your podcast to download and subscribe to it. Please leave a comment, please share. We could use a little help.
Yeah, like and subscribe. And if you have any topics that you would like us to bring to the audience, we'll be happy to take suggestions too. So you can contact me or Dave and let us know what kind of topics you want us to talk about, and we're happy to do that. So with that said, we appreciate all of you for being part of Blueprints and Banner. Like and share, and we look forward to seeing you next time.
Take care.